After a California DUI arrest, choosing blood means the state now has a physical sample, not just a machine reading. That can matter because the sample may be preserved, reviewed, and in some cases retested by an independent lab. But a blood result is not automatically the final word. The way the sample was taken, stored, and analyzed still matters. The draw usually happens at a hospital, clinic, or jail, and it should be done by a trained phlebotomist. The technician is supposed to use a non-alcohol swab, draw enough blood, and place it into a properly labeled tube with preservative and anticoagulant. Those details are not paperwork trivia. If a basic collection step was skipped or done carelessly, the result is worth examining. After the draw, the vial should go into a sealed evidence kit, be refrigerated, and then be sent to a crime lab. The chain of custody means every person who handled the sample should be documented. At the lab, alcohol is usually measured with gas chromatography, which separates and measures chemicals in the sample. Calibration, analyst training, contamination, and fermentation can all affect whether the number is reliable. One key point with blood is the blood split. That means a portion of the sample may be sent to an independent laboratory for retesting. This should be discussed early because blood samples can degrade over time. If the independent result and the state result do not match, that difference becomes important evidence to evaluate. A blood test measures your blood alcohol level at the time of the draw, not automatically at the time of driving. Alcohol can still be absorbing after the last drink. If there was a meaningful gap between driving and the blood draw, the state may need to explain what your BAC likely was earlier. This is the rising BAC issue, and the timeline matters. A DUI arrest creates two tracks: the DMV hearing and the criminal court case. The DMV may rely on the DS-367, the officer's sworn DMV form, along with the reported blood result. In court, the prosecutor may use the lab report as evidence. Separate from the lab science, Penal Code Section 1538.5 allows a motion to suppress evidence, which means asking the judge to keep evidence out if the stop, detention, or arrest violated the law. If you chose blood, write down the drinking timeline, the stop, the arrest, and anything you remember about the draw while it is still fresh. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.